asylum seeker or refugee status, judicial review. What is judicial review? One judicial review refers to the power of a court to consider and set aside administrative decisions or delegated legislation. The idea that administrative decision-makers cannot exercise powers beyond those conferred on them in law is a fundamental feature of South Africa's constitutional democracy. Similarly, public and private bodies that exercise public powers and functions ought to be regulated in terms of law. Not surprisingly, judicial review remains the most significant remedy for maladministration. Law governing judicial review. 2. Section 33 Art 1 of the Constitution of the Republic of South Africa. The TO Constitution provides that everyone has the right to administrative action that is lawful, reasonable, and procedurally fair. The right to administrative justice is accordingly entrenched in the Constitution. 2. Section 33(3) goes on to provide that national legislation must be enacted to give effect to these rights, and must a. provide for the review of administrative action by a court or, where appropriate, an independent and impartial tribunal, b. impose a duty on the state to give effect to the rights in subsections 1 and 2, and promote an efficient administration. 3 in 2000, the Promotion of Administrative Justice Act 2, PAJA, was adopted by Parliament in accordance with Section 33(3) of the Constitution. Judicial review of administrative action is now primarily governed by PAJA, which not only regulates the procedural fairness requirements that need to be met by administrators but also sets forward substantive grounds for judicial review and regulates the procedure for judicial review as well the remedies available in judicial review proceedings. 2. Ordinarily, anyone who wishes to review administrative action must now base their cause of action in PAJA. While the Constitutional Court has carved out another exclusively constitutional basis for reviewing any exercise of public power, including administrative action, that being review for non-compliance with the rule of law principle of legality review, according to a recent decision of the Supreme Court of Appeal. This ground of review is only available when PAJA does not apply. Thus, where any conduct decision sought to be reviewed by a litigant constitutes administrative action, as per the definition contained in PAJA, the review proceedings must be brought in terms of PAJA.